All right, good morning. This is a hearing by the Refugee Appeal Division under the Immigration and Refugee Board in Vancouver, BC. It's February 27th, 2014. My name is Caitlin Maycock. I will be representing the Refugee Appeal Division and making the decision on your appeal today. The Immigration and Refugee Board is an independent tribunal which operates under the Immigration and Refugee Protection Act. The subject matter of this hearing is the appeal of Ms. Erin Granson from China for reconsideration of the refugee protection request represented by Mr. Alvin Manigo. Will the appellant and representative please raise their right hand and affirm? I solemnly affirm that the evidence to be given by me shall be the truth, the whole truth, and nothing but the truth.
I do.
Yes, I do.
Thank you. In this hearing, I, Caitlin, Ms. Rajni, and Mr. Joseph are adjudicators. We also have the Minister's Counsel, Mr. Benji, Ms. Haiti, and Mr. Akeem as the expert witnesses who will be given time to speak. In this hearing, the Minister's Counsel is allowed to ask questions first, then I and the other members will ask a number of questions. The questions are for the purpose of gathering information to allow to make a fair decision about your claim. If the questions are not clear, please say so that we may clarify for you. During the questioning, the witness will have the opportunity to speak. However, they will remain silent and will only speak when spoken to. Finally, your representative will be given a chance to submit consideration of the submitted evidence. Today's hearing will determine the appeal of the Refugee Protection Division decision from October 28, 2013, that Erin does not qualify for Canadian protection as her identity has not been properly established. In addition, a written notice of decision was provided, dated November 14, 2013. Pursuant to paragraph 3, section 1, subsection A of the Refugee Immigration Protection Act, the Refugee Appeal Division confirms the determination of the Refugee Protection Division, namely, that the appellant is neither a convention refugee pursuant to section 96 of the Act or a person in need of protection pursuant to section 97 of the Act. We will begin with a statement from the appellant and her representative, as well as the presentation of the new evidence. We will then have a 15-minute recess, after which we will have time for any additional information to be presented. A decision will be rendered to you via written response as soon as possible. Do you have any questions in regard to today's proceedings?
No questions.
Thank you. Erin, please state your full name, citizenship, and date of birth.
I am Erin Lee Granson. I am 47 years old and I'm a citizen of China. Thank you.
Thank you. Council's representative, please state your full name, address, and qualifications.
Good morning, everyone. I'm Alvin Manigo, residing in CDI College, a licensed immigration practitioner. I've been in the practice for 5 years now. Thank you very much.
Thank you. Now, will Minister's Counsel, Mr. Bajneet, ask any questions to the appellant?
Good morning, everyone. Would you please, Erin, describe for us the situation which led you to leave China?
I came to Canada in 2006 on a visitor's visa to stay with my cousin who lives in Vancouver, Canada. At the time, I was living in Hong Kong, China with my father and 2 sons. My boyfriend was physically abusive to myself, my 2 sons, and both of my parents on several occasions. I was also in fear of the family planning authorities in China because in 1991, I gave birth to my second child, which was against the violation of the one-child policy that was in effect. My father thought that it would be a good idea for me to leave Hong Kong for a while so that I could escape the abuse from my boyfriend and fear that I was under from the family planning authorities. So for these reasons, I applied for a visitor visa that was approved for 6 months that would be valid from January 15, 2006 to July 15, 2006.
Okay. So what route have you taken to enter Canada and where did you arrive first?
I entered in Canada by plane on a direct flight through China Airlines flight C1007 and arrived in Vancouver on January 20th, 2006.
How long have you been in Canada for?
I have been in Canada for 7 years since my arrival on January 20th, 2006.
Have you ever left Canada since your arrival?
No, I have not left Canada since my arrival.
So, Miss Erin, you mentioned you lived with your cousin when you came to Canada first. Who do you live with now?
I have continued to live with my cousin in Vancouver, Canada.
Okay. So what have you been doing in this time? Have you ever worked in Canada?
I do not work, but I have been helping my cousin with daily household chores, as well as looking after her now 10-year-old daughter, who is my niece when my cousin is working. When I first arrived in January 2006, I spoke little English, so I did take a 2-month language course to help my English so that I could better communicate with other people in Canada.
As we have yet to fully establish your identity, have you obtained any documents from Chinese authorities since the denial of your claim which you wish to present today?
I would like to present the translated hukou for myself, my father, and my 2 sons. These documents will better prove all of our identities because they have now been submitted in the English language.
Miss Erin, would you please explain why you allowed your visitor visa to expire and also explain the 7-year delay in submitting your refugee protection claim?
At the time when my visitor visa expired on July 15, 2006, my cousin was going through a very hard time after the loss of her boyfriend, who was suddenly killed in a car accident. Her boyfriend was also the father of her then 3-year-old daughter. With so much going on at the time with the preparation of his funeral and all of the legal documents that resulted from the car accident, it was extremely stressful, and I was taking on a lot to help my cousin and her daughter during this difficult time. I couldn't apply to renew my visa. After my visa had expired, my boyfriend, who still lived in China, told my parents that if I returned to China, he would kill me. The news scared me, and I also feared for my life if I returned to China. And I was also still fearful of the family planning authorities because of the one-child policy in China. The reason that I did not submit my refugee protection right away because I had so much anxiety about how I was able to get my 2 kids to Canada. Because my sons were doing well in China with my parents, I was reluctant to pull them away and move them to Canada, where it would be such a big adjustment for them. I thought if I waited until they were older, it would be easier for them to move to Canada.
Thank you. Over to you, Miss Caitlin.
Thank you. Now Mr. Joseph will ask questions to the appellant.
Okay, Mrs. Erin, can you explain why in 7 years' time you were unable to obtain the required document and translations?
The reason why I was unable to provide these documents is because they went missing, and I was unable to find them for some time. I submitted a request to the Chinese government to obtain a new hukou, but with the corrupt government issues that were going on, I was unsuccessful. It was not until November 2013 that I was able to find the hukou and then get them translated so that I could file my appeal.
Okay, have you obtained the required translation for your hukou to provide us today?
Yes, I have received the translated hukou for myself, my father, and my 2 sons.
Why does the hukou issue in 2010 doesn't contain your son's name yet? They have been living with your parents since 2006, and so will be recorded on the hukou.
It is a Chinese regulations needed time to process the hukou under my father's name to include my sons.
Can you tell us exactly what the main reason for your refugee claim?
My boyfriend has told my parents that if I return to China, he will kill me, and I have fear from the family planning authorities as well.
Okay, thank you.
Thank you, Joseph. Erin, please give a brief description of the events surrounding your relationship with your boyfriend that led you to believe your life is at risk.
My boyfriend was physically abusive with me whenever he was drinking alcohol heavily. When I knew he was drinking, I always tried to get myself, my 2 kids, and my parents away from him. But most of the time, they would come to my parents' house after he had been drinking, and that is when he would start arguments and become physically violent towards us. He would sometimes throw things or push us down the stairs.
Why did you leave your parents and children behind when you feel they are also at risk of abuse from your boyfriend, but then still wait 7 years before seeking assistance?
My father thought that I should go to Canada by myself because my boyfriend was abusive mostly to me. My parents and my two sons moved into another house owned by my auntie for a while until things settled down and it was safe for them to go back into their own house. That was why my father felt that they could continue to raise my two sons in a familiar place instead of uprooting them and moving them to Canada.
Does the Minister's Council have any more questions?
Yes, Miss Caitlin, I have questions. So, Miss Erin, would you describe your experiences with the family planning authorities?
My experiences was not very good because the Family Planning Authority holds so much power. Because I have an unauthorized child, they have the right to deny me such things as education, medical treatment, loss of employment, or prevent me from obtaining future employment.
So, were there any feared repercussions of the outstanding fines should you return and yet have to pay?
The government has been known to simply withdraw the money from your account in the event that you have not paid the fine in full. The outstanding fine, which is 10,000 renminbi, is 5 times higher than my annual income, and there is no way that I can afford to pay this.
Thank
Ms.
you.
Erin, in the preview hearing, evidence was to be submitted in relationship with your sterilization by authorities in 1991. Please explain why no such evidence has been submitted.
In the previous hearing, in China, the system is complicated when you apply to get certain documents, as they need your physical presence.
But a medical letter was written on prescription paper by your father regarding an injury to your nose. However, this neither established identity does not provide enough evidence as to your need for protection. Please explain what you think to be importance of this letter on your case.
I felt that this was important evidence to include because it showed the abuse that I had received from my boyfriend.
Mr. Joseph, do you have any further questions?
No, thank you.
Thank you, Ms. Erin. Minister's Counsel. Sorry, Mr. Counsel, do you have the new piece of evidence to be presented in this appeal?
Yes, Ms. Caitlin. As a matter of fact, I do have new pieces of evidence to be presented in this appeal. Exhibit 1, copy of the appellant's passport. Exhibit 2, Royal Canadian Mounted Police identification number for stolen passport. Exhibit 3, certificate of village committee sterilization. The appellant came forward and made refugee claim in August 2013. The appellant alleges that her problem in China are twofold. The appellant stated that she has two boys in China that were born in 1989 and 1991. Her second child was born in violation of one-child policy in China. As a result of this violation, the appellant was sterilized in 1991 and also fined 20,000 renminbi. The appellant's mother has paid a portion of the fine, but there is 10,000 renminbi that remains outstanding. As a result, the appellant fears the family planning authorities in China. In Exhibit 4, Certificate of Erin Granson Health Center. The appellant alleged that she was in abusive relationship with her boyfriend in China. The appellant alleged that her boyfriend physically assaulted on her numerous occasions and that he has also assaulted her children and parents. The appellant continues to fear her boyfriend as she has told her parents that he would kill her and if she returns to China. Exhibit 5, the Huku page of Jackie Chan, the appellant's father. Exhibit 6, Huku page of appellant. Exhibit 7, translated Huku page for Jackie Chan. Exhibit 8, translated Huku page for the appellant. Exhibit 9, translated Huku page for Bruce Lee, the appellant's son. And Exhibit 10, translated Huku page for Jack, the appellant's son. That is all I'm going to present. Thank you very much, Ms. Caitlin.
Thank you, Mr. Counsel. Minister's Counsel, do you have any questions?
No further questions. Thank you, Ms. Caitlin.
Thank you. Can the expert witness come forward and introduce yourself? Before moving further, I would like you to raise your right hand and swear an oath before this tribunal. Do you solemnly affirm that the evidence to be given by me shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you please tell us what is the one-child policy in China and what are the consequences?
My name is Heidi Arceo. I work in ABC, a non-government organization which cater the plight for women in China. One-child policy is a official program initiated in late 1970s and early 80s by the central government of China, the purpose of which was to limit the great majority of family units in the country to one child each. The rationale for implementing the policy was to reduce the growth rate of China's enormous population. China began promoting the use of birth control and family planning with the establishment of the People's Republic in China in 1949. Though such efforts remained sporadic and voluntarily until after the death of Meng Zedong in 1976. By the late 1970s, China's population was rapidly approaching the 1 billion mark, and the country's new programmatic leadership headed by Deng Xiaoping was beginning to give serious consideration to curbing what had become a rapid population growth rate. A voluntary program was announced in late 1978 that encouraged families to have no more than 2 children, one child being preferable. In 1979, demand grew for making the limit 1 child per family. However, the restrictor requirement was then applied unevenly across the country among the provinces. And by 1980, the central government sought to standardize the one-child policy nationwide. On September 25, 1980, a public letter published by Central Committee of the Chinese Communist Party to the party membership called upon all adhere to one-child policy, and that date has often been cited as a policy's official start date. Methods of enforcement including making various contraceptive methods widely available, offering financial incentives and preferential employment opportunities for those who complied, imposing sanctions against those who violated the policy, and at times invoking stronger measures such as forced abortion and sterilization. Those who violated this one-child policy will be fined and sterilized. If the couple governed by one-child policy have more than one child, they are fined to 370 to 12,800, an amount many times an average annual income of many Chinese. If a couple is unable to pay the fine, they may lose their jobs, their land, their livestock will be confiscated, their home destroyed, their children will be denied their rights and benefits of a state like education, and their child will be taken away. The woman will also be forced to be sterilized. If a family planning official discovers that a woman is having an illegal pregnancy, meaning having a child without birth permit, he or she can force the woman to have an abortion. The Chinese government has ensured terrible consequences for failing to comply with the one-child policy. In China, men still have greater marital power, which increases fertility pressure on their female partners. The dynamic of relationship held by each parent and the amount of resources each parent has contributed to struggle for dominance. Resources would be such items of income and health insurance. Dominance will be described as who has the final say in pregnancy, who must resign in their career for maternal and parental leave. However, women have shown interest in the second child if the first child did not possess the desired gender. Thank you.
Thank you. Does the Minister's Council have any other questions?
No, Ms. Caitlin, I do not have any questions to ask to the witness. Thank you.
Mr. Akeem, can you enlighten us what is a huku? But before moving forward, I would like you to raise your right hand and swear an oath before this tribunal. Do you solemnly affirm that the evidence to be given by you shall be the truth, the whole truth, and nothing but the truth?
Your mic.
You're muted, Akim.
I solemnly affirm that the evidence I'll be given will be truth and nothing but the truth.
Thank you, Mr. Akeem. Go ahead.
Good morning, ladies and gentlemen. Please kindly permit me to introduce myself. My name is Akeem Aware, a professor of comparative public administration with specialization and expertise in Chinese politics and public administration. I currently work for the University of Alberta and also consult for the United Nations. I've been invited here today as an educating witness on the huku system in China. Huku in Chinese literally translates to household individual. It's a system of household registration used in mainland China. The system itself is more properly called huji, which in Chinese literally means Chinese household origin. It has its origins in ancient China. The formal name for the system is huji. Within the huji system, a huku is the registered residency status of a particular individual in the system. Ku literally means mouth, which originates from the practice of regarding family members as mouth to feed, similar to the phrase per head in English. Huku is issued per family and includes identifying information such as names, parents, spouse, the date of birth, deaths, marriages, divorces, and moves of all members in the family. The system descends in part from ancient Chinese household registration systems. Owing to its connection to social programs provided by the government, which assigns benefits based on agricultural and non-agricultural residency status, often referred to as rural and urban, the huku system is sometimes likened to a form of caste system. It has been the source of much inequality over the decades since the establishment of the People's Republic of China in 1949. As urban residents receive benefits that ranged from retirement pension to education to health care, while rural citizens were often left to fend for themselves. In recent years, the central government has begun to reform the system in response to protests and a changing economic system. But experts speculate as to whether or not these changes have been of substance. The rationale and function of the huku system. In its original legislation, the huku system was justified as created to maintain social order, protect the rights and interests of citizens, and to be of service to the establishment of socialism. In its current version, the huku fulfills three main functions: the control of internal migration, 2, the management of social protection, and 3, the preservation of social stability. The control of internal migration is the first objective of the system of huku. All Chinese citizens need a huku residency card to live in a city named on the card or to move from one place to another. The huku is also a kind of internal passport. It was implemented in 1958 to halt migration, control grain rations, and keep tabs on the masses and give rural people a connection to their land. Thank you.
Thank you very much, Mr. Akeem. Rajni, can you please read the closing statement?
Is mute.
You're muted.
Rajni, you're muted.
Ms. Rajni, you're muted.
After listening to the people and the evidences and the testimony from expert, I noted that exhibits 1 to 6 were entered into the record at the time of the Refugee Protection Division hearing, and thus constitute evidence in the Refugee Protection Division record on the file. These documents, therefore, do not constitute any new evidence pursuant to subsection 110 of the Act. Counsel of the appellant in her submissions indicates that she disagrees with how the Refugee Protection Division member considered some of these documents in his reasons. Counsel's arguments will be considered later in these reasons as they pertain to these documents. The appellant has submitted various documents as new evidence pursuant to subsection 110 of the Act that was not reasonably available to the appellant, or that the person could not reasonably have been presented at the time of the rejection of her claim. Exhibit 7, translated Huku page for Jackie Chan, who is the father of the appellant. Exhibit 8, translated Huku page for appellant Aaron. Exhibit 9, translated Huku page for Bruce Lee, who is the elder son of the appellant. Exhibit 10, translated Huku page for Jack, who is the younger son of the appellant. Subsection 110 of the Act provides that appellants may present only evidence that arose after the rejection of their claims, or that was not reasonably available, or that they could not reasonably have been expected in the circumstances to have presented at the time of the rejection. In Raza, to the Federal Court of Appeal set out factors to be considered is in assessing new evidence. While Raza predates the introduction of Act subsection 110, it is based on the very similar wording of subsection 113. The court held that new evidence should be considered for its credibility, relevance, newness, and materiality in addition to these express statutory provisions. I also noted that documents submitted as Exhibits 7 and 8 are pages of the appellant's Huku. These documents were actually submitted without translation as evidence to the RPD and are marked as Exhibit 7 in the RPD record. The interpreter of the RPD hearing assisted in 2 Raza versus Canada, that was Minister of Citizenship and Immigration, understanding the contents of the untranslated Huku. Counsel for the appellant has submitted that the appellant was unable to obtain translations for the documents given the short timelines required prior to the RPD hearing. However, I find this explanation to be inadequate to explain why important identity developments had not been submitted and translated as clearly required and explained to refugee claimants in the appendix to the basic of claim form. Furthermore, as the Huku had been entered into evidence at the time of the RPD hearing, while I do not accept them as new evidence, I will consider them when dealing with the merits of the appeal. Exhibit 9 and 10 appear to be pages of the Huku in the name of the appellant's father as head of household that refer to the appellant's sons. These documents appear problematic in that at the time of the RPD hearing, when the appellant presented her Huku, the RPD reasons indicate that the Huku presented to the RPD member did not have these pages. The appellant at the RPD hearing was unable to explain why her sons were not registered in her father's huku. Exhibits 9 and 10 have been submitted to the RAD with no further explanation as to their provenance or why they were not presented at the time of the RPD hearing. I therefore decline to accept these documents as evidence. Application for the oral hearing subsection 110 of the Act requires that the RPD proceed without a hearing on the basis of the RPD record, while allowing the RAD to accept documentary evidence and submission from the minister and appellant. According to subsection 110, the RAD may hold a hearing if, in its option, there is documentary evidence referred to in subsection 110 that raises a serious issue with respect to the credibility of the appellant. That is central of the RPD decision, and that, if accepted, would justify allowing or rejecting the refugee protection claim. When read together, subsection 110 and 6 establish that the RAD must not hold a hearing in an appeal such as this unless there is new evidence. Number 4 is, in which case the RAD may hold a hearing if that new evidence raises a serious issue with respect to the credibility of the appellant is central to RPD decision, and that, if accepted, would justify allowing or rejecting the refugee protection claim. I find that the issues raised in this appeal relating to the RPD members' identity and credibility findings are issues of fact. The RAD has afforded a considerable level of deference to RPD findings on questions of fact in this claim, and will consider whether the findings of fact raised in this appeal related to the RPD members' identity and credibility findings meet the reasonableness test. Analysis of the merits of the appeal. It appears that the huku submitted at the RPD hearing did not have these pages. Given the concerns expressed by the RPD member, I find that his assigning to weight to the huku was reasonable. Ultimately, I am unable to find any reason to overturn the RPD decision based on the evidence provided because the appellant has still not been able to satisfy the documentary evidence requirements nor able to prove the basis of her refugee claim, because the appellant states that her claim should be determined upon country conditions rather than personal circumstances. Based on the totality of the evidence, I find that the RPD members' findings of fact as it related to credibility and identity were reasonable. The RPD member did not mistake or misconstrue the evidence in coming to his fear and supported credibility findings. Where an applicant has not established identity, a negative conclusion as to credibility will almost inevitably also be drawn, and in and of itself can be determinative of the claim. Given the lack of acceptable identity documentations, it will open to the RPD to reject the applicant's explanation and to impugn her credibility, having considered all the evidence. I find that these reasons to fall with a range of possibility acceptable outcomes which are defensible in respect of the facts and law. For all these reasons, I confirm the determination of the RPD, namely, that the appellant is neither a convention refugee pursuant to Section 96 of the Act, nor a person in need of protection pursuant to Section 97 of the Act. This appeal is therefore dismissed.